Hello and welcome to Moneycontrol. My name is Ashwin Mohan, and you're watching a brand new episode of Deal Central, where we get you the views that matter from the world of mergers and acquisitions, private equity, and equity capital market deals. Last week, based on an appeal by operational creditors and others, the Supreme Court cancelled the 19,350 crore acquisition of Bhushan Power and Steel by JSW Steel, terming it illegal and in violation of several provisions of the insolvency and bankruptcy code. That's not all. The top court has also ordered the liquidation of Bhushan Power and Steel. The tricky part? Well, the successful resolution plan of JSW Steel had got the approval of the COC, the NCLT, as well as the NCLAT many years back, and this was between the time frame of October 2018 and February 2020. So the big question today is, how do you unwind a transaction in which the asset has already been integrated with the buyer and where the monies have been disbursed? Not surprisingly, this order from the top court has sent ripples across corporate India, and to understand the implications of this order on all IBC stakeholders, whether it's the buyers, the sellers, the lenders, and also the implications on India's bankruptcy law, we are joined today on Deal Central by Nilang Desai, senior partner at AZBN Partners, and Abizer Diwanji, founder, NeoStrat Advisors LLP. Gentlemen, always a pleasure speaking to the two of you, and welcome to the show.
Thank you.
Thank you.
Right. Nilang, let's go straight to the heart of the matter. The reason why the Supreme Court rejected the plan of JSW Steel in the first place. The top court has rejected the plan, saying that it did not comply with provisions of Section 30 of the Insolvency and Bankruptcy Code, or IBC, read with Section 31. Now, Section 30 deals with submission of the resolution plan. Section 31 deals with approval of the resolution plan. Do you think that the top court, with this very firm verdict, has sent a clear signal to all IBC stakeholders that all the procedures have to be followed to the T, have to be followed very strictly, and that the procedure is sacrosanct? Otherwise, you should be ready to face the consequences. Opening thoughts, Nilang.
I think the law on this point is clear. I think the practice on this point is clear. I don't think any member of the faculty, any member of the profession had any illusion as to the importance or criticality of these procedures. I don't think that's the message. I think, unfortunately, the message is that even 5 years after implementing and closing something, the tables can be turned completely. Commercial realities may not be as relevant, and the toothpaste has to be squeezed back into the tube.
Abizer, what are your thoughts on the reasons behind why the Supreme Court rejected the JSW Steel plan?
Well, my opinion, there is no logic to this plan. If you're asking me for reasons, there is no reason why this should happen. The official reason, of course, is not following procedure. But not following procedure has to impact somebody adversely. And that implication can result in punitive action. That's when it would have been justified. So when I say that there is no justification, it's because there is no aggrieved party in this. There were two parties who, along with JSW, bid for this thing. They have not even appealed once. So they are not the aggrieved parties. The case on which these three people were actually, the resolution plan was actually turned around and the procedures were looked into, was because the operational creditors said that the procedures were not followed. Now, if the financial creditors, who are are supposed to be a priority in terms of repayment, do not receive the full amount intuitively, the operating creditors should not get that amount. Having said that, the financial creditors got less as a percentage of recovery than the operating creditors did. So fundamentally, the operating creditors need not have been aggrieved by this by the earlier resolution plan. If they were not aggrieved, then what are you trying to solve? And I think that's the reason why I think this whole judgment does not serve anybody.
And Abizer, just to your point, as a matter of law, the operational creditors were due zero. So this was,
Yes.
in a sense, a top up that the resolution applicant was providing.
I mean, they got paid 50% of their dues.
Yeah.
Right. So opening thoughts in from both of the panelists over there. But the larger question is also, what does this verdict mean for finality of resolution plans that are approved by the IBC, and also the potential for judicial intervention? In this case, the intervention has come in from the top court of the land 5 years after the original approval or nod to the resolution plan. So there are certain quarters in the industry that believe that now there'll be a looming fear that unless cleared by the top court, every IBC resolution plan stands the risk of being overturned. Is that an exaggeration of the current outcome of the Supreme Court? And and if that's the case, if that's an exaggeration, would it merely depend on just the facts of each case? Because this one is a rather unique case.
Abizer, should I jump?
Yeah. I think let's go Nilang with you doing the first answering.
Sure. No, exactly right, Ashwin. I think that's exactly what the fear is going to be. That if there is a pending Supreme Court appeal, then effectively until that is resolved, there is no certainty. No matter how many years have passed between implementation and eventually when the Supreme Court has the time. And that will have a rippling effect, already is having a rippling effect throughout the industry. If I'm a bidder, do I want to close and pay up? No, I want finality. If I'm a creditor, I want the money, but what can I tell a bidder? There is a live example where 5-6 years after implementation, after plan approval, things have been reversed. So will the creditor have to refund the money? Will the bidder now ask creditors that you have to sign an undertaking to refund all the money, maybe with interest, if there's a reversal? Can lenders sign it? Can foreign funds sign it? Can Indian banks sign it? How do they provide for it? Resolution professionals, what's the lesson for them? I think there are just so many impacts which we will see in the days to come in terms of market practice, in terms of how bidders react. I think there are a lot of worrying aspects which have to be dealt with.
Right. Abizer, what does this verdict mean for the sanctity of the Insolvency and Bankruptcy Code, which of course has been ushered in to ensure timely resolution, and it has been ushered in to also introduce financial discipline. But what does this mean for the sanctity of the entire IBC?
So fundamentally, this has been overturned because of process not being followed. And I'm not getting into the facts of it, but I'm just saying somebody took a call many years later on an appeal by operating creditors that process was not followed and hence it was overturned. Now let's examine this. One, from various stakeholders' point of view. The RP is going to become super conscious on process and the letter rather than the spirit. And in that process, he will lose the biggest advantage that IBC has, or the objective rather IBC has, which is maximization. Maximization of any value requires a level of flexibility. If you take away every form of flexibility and say, oh, you did not file a Form H, and that's why I'm going to come after you, it's not going to help. No businessman, no entrepreneur, and an RP is an entrepreneur when he is running the CIRP. No entrepreneur can survive when every move is followed by a regulation. So I think now...
But Abizer, hold on to your thoughts. Who will decide to what extent should one adhere to procedure so that it does not invite a rap on the knuckles? Who decides that?
Nobody needs to sit in judgment. What needs to happen is you offer him the flexibility within the overall law. The IBC Act, in my opinion, is the best possible drafted act. What has messed it up is the regulation. But the act is so well done that if taken in the spirit, and if the RP is evaluated on the biggest spirit, which is whether he has tried his best to maximize value, that is an appreciated fact. And the courts should be capable of deciding that. They don't need rules to decide that. You don't need to peg people down on rules. Take this particular case in instance. And if you were to compare the fact that did the RP make sure that value was maximized through a process that he followed, which he thought best in the circumstance. Do remember, every insolvency is bespoke. So if he has maximized value and there's no reason on that, then he has done his job. Whether he's
Sure.
filled a particular form or no can't be the basis. Now what's going to happen is he's going to focus on the form filling. Second, the committee of creditors, the very basis which Swiss Ribbons has established, which is that the creditors have the ability to take commercial decisions on their own, has been questioned. Because the courts went and said, you've not taken your decisions well. On what basis, one doesn't know. But you didn't follow process well. How could you have approved an extension to a timeline, without every member of the COC coming to it? Yes, but think about it. You were in the middle of a PMLA, and a PMLA at a time when there was ambiguity around before 32A came in.
And in the middle of COVID, Abizer.
The middle of COVID, there were many such issues. So at the end of
Right.
it, understand the circumstance. And in that, you did not pass one resolution. Big deal. Did it really impact anybody? If another bidder came and said, I have been wronged, I think that should be evaluated. So what I'm saying is that the whole process will become, of insolvency will become more process oriented, more process conscious, I would say. And that will actually impede the biggest objective that IBC wanted to achieve, which is maximization of value.
Right. All right. Now, Nilang, point taken, Abizer, pushing for more flexibility as far as the implementation of the code is concerned when it comes to the various stakeholders. Now, Nilang, I was reading the order and, I was just wondering, having rejected the JSW Steel resolution plan, do you think the court perhaps could have exercised the option of, after rejection, sending the case back to the lower tribunal for adequate redressal of any of the anomalies which they believe had taken place? In this case, of course, the Supreme Court has invoked what many are calling the rare nuclear option. They've invoked Article 142 of the Constitution of India, which is a rather unique power that the apex court has to pass any order necessary to ensure complete justice. So, your take on this? On one hand, you've rejected the plan, but could they have sent it back to the lower tribunals for a fresh look?
They could have, and effectively they have in a sort said, listen, lower court to pass the liquidation order and related aspects. Now, there are two ways to look at this, Ashwin. If they had left all the consequences down to the NCLT, then you go back to NCLT, NCLT takes a certain view, then you appeal to NCLAT, comes back to Supreme Court again 4 years later. So you're stuck in a loop for another 2 to 4 years to decide the consequences of this judgment. So there is that aspect of delay, and it's almost at times better for the Supreme Court to arrive at the conclusion and the consequences as well. But on the flip side, how do you squeeze toothpaste back into a tube, right? And there are so many aspects to be considered. It's not as simple as saying click and go into liquidation. So perhaps if it had gone back to an NCLT, the more granular, the more relevant, the more important aspects of how the impact of this finding should be, set out would have been thought through by the NCLT. So difficult choice,
Right.
Ashwin.
Right. I get where you're coming from, and you've already spoken about the fact that there are several aspects that need to be considered, and that tempts me to ask you: would it perhaps have helped if the roadmap for how to go about the entire unwinding of this mega deal would have found mention in the Supreme Court, some sort of a blueprint or guidance from the Supreme Court in that direction, perhaps would have made it less stressful for the stakeholders who now have to follow the directions?
I think as we will see in the coming days, unwinding this process is so problematic and so complicated. Setting that out in the judgment would have taken several more months to write it, perhaps.
All right. Now, Abizer, Section 29 of the IBC, the Insolvency and Bankruptcy Code, the controversial Section 29A of the IBC, all three of us have discussed it in the past when it came to the SR Steel case. That also finds mention in various portions of the Supreme Court verdict. The order says the resolution professional utterly failed in discharging his duties by not certifying JSW's eligibility under Section 29A of the IBC. What's the clear message that the court is sending to RPs out there?
Well, I think that the message is fair to say that everybody needs to do a clear assessment of 29A. And there is a particular form in which, Form H, I think, which has to be certified that a person has to be done. So I don't think that there the Supreme Court is wrong in terms of asking the question to say why wasn't due process followed in terms of the 29A. But again, look at the essence of this 29A. Right? JSW had some kind of a joint venture with Bhushan Power and Steel, and that was the point of contention to say that, oh, the 29A was not proper. That I don't agree with. Because obviously, if you're in the steel business, you would have certain joint ventures. And not every joint venture is a backdoor entry by the promoter to buy the company. Now, let me also tell you the bigger anomaly that I see in this judgment is, on the one hand, you say that there was a surrogate way, possible surrogate way, that the RP utterly failed in terms of identifying a 29A, potential 29A issue. What does that really mean? That the promoter is trying to come in through a backdoor entry. That's what 29 is for. Correct? And to the utter surprise of everybody, this whole petition by the Supreme Court is basis a case filed by the promoter. On the one hand, you have 29A, which says that the promoter should not be bidding and the RP utterly failed. On the other hand, one of the petitions that you have encouraged and given a ruling basis on is from the promoter. Where does that put you? Is the Supreme Court 29A non-compliant then? Question to ask.
Right. Nilang, there's another aspect to the resolution professional's conduct, which the Supreme Court has highlighted. Now, the order highlights that the resolution professional did not file any application of extension of time for implementation of the resolution plan. Now, we all know that the outer limit is 240 days, but according to the Supreme Court order, there was an intentional delay of more than 540 days, and the Supreme Court says that the COC was party to this. In fact, they've also said that there is no material placed on record as to how, when, and who sanctioned the effective date as stated in the resolution plan. That's quite strange and peculiar, right? Somebody has to own up to such a key decision. What are your thoughts?
The point about the Form H and the 29A declaration by the RP, this point about the extension, your point about the RP not having complied with his obligations, these are all highly factual points, right? So either he's done it or he's not. None of this is new. None of this is taken lightly by any RP. And remember, this is an RP in a case who's well advised by significant and serious professional advisors. So we will find out in the coming days whether, as a matter of record and fact, the RP did comply or did not comply. But I think the point to make over here is, what is the takeaway for a resolution professional? If indeed we find out in the days to come that they had complied and this was a matter of record, if really you're telling the RP, in terms of your compliance, emphasize your compliance and then re-emphasize it, and then emphasize it some more, just so that someone in the top court doesn't miss out on it. If indeed it is the case that as a factual matter, all of this was not done, that's a question of law, and that's an issue, admittedly. But we need to figure out factually what is the correct space. And in terms of the extensions,
the factual matrix will perhaps be more clearer in the coming days, like you're saying. But definitely, the RP has been pulled up in several parts of the Apex Court's verdict. Abizer,
I have a point here. See, you can say, and I agree with Nilang, that at the end of the day, it is a factual situation whether the plan was approved, the extension was sought, not sought, whatever. Assuming it was not sought, let's take the worst case situation. Correct? And I go back to your nuke discussion. I know it's fashionable to pull out nukes nowadays, thanks to Project Sindhu. But do think about it. Is the answer to this putting a company which has been running successfully for 4 years into liquidation? Even if these are lapses, what are we really worried about? We are not saying that these lapses should not be cured. But is the cure liquidation?
So what's the non-liquidation route that perhaps the courts could have taken, Abizer? If not liquidation, then what? Impose fines, penalties?
Well, you asked Nilang that question earlier. And I don't know legally, but even if it is pushed back to the NCLAT or the NCLT, or if the Supreme Court says that I want to impose punitive measures, to say pay interest because of the delay, or the RP is actually reprimanded, that process needs to be followed. And why reprimanded? Because there is no aggrieved party. Why interest? Because there is no aggrieved party. If there was one aggrieved party in this which said that I have lost out because preferences or lack of procedure, then what the Supreme Court talks about unwinding is possible because you have another buyer who's willing to pick it up.
Right.
Here you have a situation where everybody is happy with this. The only person who's not happy is people who are not eligible to get anything and the ex-promoter. I think the consequence here should have been penalty if you want and reprimand to the RP. That can
Right.
happen for not following process if proven. As Nilang said, these are factual issues. If proven.
Right.
That
All right.
I would agree with.
All right. Point taken, Abizer. Point taken. Nilang, I want to highlight what MS Sahu has said. He, of course, is the first chairperson of the Insolvency and Bankruptcy Board of India and respected gentleman. In a post on LinkedIn, he says that the verdict is legally sound but economically hollow. In fact, he says no prudent business would invest in a process where a concluded and implemented commercial transaction remains indefinitely exposed to risks. He goes on to add that undoubtedly the discovery of illegality must trigger swift and proportionate consequences, but that cannot extend to invalidating the transaction itself. He's echoing what Abizer mentioned just a short while back. So, Nilang, what do you make of Mr. Sahu's take on the verdict? And I'm going to pose the same question to you. If not the new option of liquidation, what else could the top court have done to set an example because they believe the procedure wasn't followed?
Sorry, on Dr. Sahu's statement, completely agree. Have the utmost respect for him, and I think he summarized it perfectly. I think the point which jumps out at me significantly there is the word proportionality, right? Which is also what Abizer was talking about. Is it disproportionate? It does seem like it. And again, it goes back to the facts and how true those facts are and how credible those facts are. What else could the court have done? I'm going to recuse myself a little bit over here because, I'm advising all the stakeholders. But maybe that's something which could have been left to the NCLT to bore down on the facts, and to the extent those facts actually play out, then do a case-by-case, consequence for each relevant stakeholder and a proportionate consequence.
Sure. Nilang, I want to also bring up one very important paragraph in the order, and maybe we can discuss whether this is a loophole that needs to be plugged to avoid a similar scenario in future when it comes to the IBC. And this is the part of the top court's order which says it is quite clear that merely because the code is silent, I quote, it is quite clear that merely because the code is silent with regard to the phase of implementation of the resolution plan by the successful resolution applicant, neither the tribunal nor the court should give excessive leeway to the successful resolution applicant to act in a flagrant violation of the terms of the resolution plan or in a lackadaisical manner. Is this an area where the code needs to be strengthened, Nilang? That's what seems to be saying, because it says the current law is silent.
Just for context, this was said in relation to the delay in implementation, that they took so long and that delay was excessive and flagrant violation, etc., etc. So that was the context. Is that an issue? I think it is certainly an issue, and something I feel quite strongly about. I know Abizer feels quite strongly about. We had discussions. Is it an issue in the IBC? I'm not sure it is. Ashwin, if I sell you a car and say we must close by the end of May, and if you don't close it, then shouldn't I have put in the contract already that if you don't close it by May, these are the consequences? Why is it so difficult for creditors to put in the resolution plans that this is the date on which you need to close, and if you don't close by this date, then this is the consequence: interest, punitive amounts to be paid, etc. That's common sense, and I know for a fact that a bunch of lawyers have advised this to be put in resolution plans. Why aren't more creditors putting this in the resolution plans upfront and refusing to take it out? That is the question.
All right. Abizer, what impact do you think this verdict, which has shaken several quarters of India Inc., will have on ongoing cases? Now, this is specifically on the JSW Bhushan Power and Steel resolution plan. But what impact do you think it will have on ongoing cases under the Insolvency and Bankruptcy Code? Because stakeholders would be perhaps a worried lot. They would want adequate protection.
Yeah, I'll just make one comment on what you asked Nilang first and then move to that very quickly. I think one of the remedies to solve this long delay problem is to include the courts within the ambit of delayed resolution plans.
All right. All right.
If you can do that, that will really help.
Okay.
And I think that is very
Fair
important.
enough.
The courts themselves have said any kind of deadlines don't apply to us. Maybe if we can amend that, that will be a better solution. So sorry, moving to the
Sure.
question you asked.
Now coming back to the impact on the ongoing cases.
Yeah, the impact. See, impact's already felt. I'm working on a couple of resolution plans where there have been some governmental cases. The government has objected to a resolution plan in a court. And one is worried. The applicant is worried, saying that if a government claims come in, I don't know which way it's going to go. It's like the PMLA claim that came in for Bush and Steel. So at the end of the day, they are saying that if such a claim comes onto us, it throws our calculations out of gear. Should we be contemplating now and doing by actually going to the courts and asking for time and saying that unless this ambiguity is resolved, we want to hold plans? That's one aspect that's happening on existing plans. People actually considering that. The other aspect is that now whenever people are going to bid for plans, they are going to see are there likely to be any further delays or any potential claims that the RP has not accepted. And are those going to result in delayed operations which can go on and on? And those will be priced into, that risk will be priced into the bids that they make. And any which way, I think the recovery in IBC has gone abysmal purely because of procedural issues and arbitrages that are there because of legal disputes. And those will only further widen. The discounts will go further up. And that's going to cause a significant impact again on the larger issue of IBC, which is maximization of value for the creditors.
On that, Ashwin, if I may make a very short point
Please
on
go ahead.
Abizer's, to follow up and supplement Abizer. One of the things you'll see in the early part of the order, the Supreme Court has pointed out that the State Electricity Board did not file a claim with the RP, did not appeal in the NCLT, did not appeal in the NCLAT. But 7 years after the process has turned up in Supreme Court, and the Supreme Court thinks nothing of that. I understand we give more leeway to the government, but 7 years delay seems absolutely fine.
In terms of filing claims, this is filing claims.
Yeah.
And enables a person, claims is the very basis on which bids are made. Think about it.
Why is this kind of apathy absolutely accepted?
All right. Now, I want to highlight
in
some of the
terms
main
of consequences. Sorry, Ashwin, if I can just take 10 seconds. Bidders are going to expect closing to move from 2 to 3 years to 5 to 7 years. Creditors will have to undertake to refund the money with interest if the plan is reversed. I don't know how they're going to do that. RPs, already a scared lot, will be terrified.
All right. Now, I just want to quickly highlight some of the main defenses of JSW. Right, JSW believes that there was no delay in implementation in implementing the resolution plan because they believe they stuck to the effective date as was stated in the resolution plan. They also believe that some of the appellants, which includes the ex-promoters, they were just trying to scuttle the entire process. And they also have pointed out that the issues regarding the implementation of the resolution plan are beyond the scope of the appeals that were filed under Section 62 of the IBC. These are a few of the defense points of JSW. Now, the pointed question to you is, what are the specific legal options available to them, Nilang? What can they do going ahead? We are all aware that there are very few cases wherein, or perhaps minimal cases wherein review petitions are entertained by the top court. But still, under the law, what options do they have? And can you also mention the timelines for each option?
I'm going to recuse myself from this answer if you don't mind, Ashwin. But broadly speaking, yes, Supreme Court order, there are review petitions, curative petitions, and they can take not weeks, but months.
Abizer, would you like to chip in? So
I don't have a legal answer because Nilang is most, and I understand is the closing. But I do think that, when a 142 can be admitted by a promoter, some kind of a natural justice kind of ability to file should be there with JSW in my view. To say that, listen, how do you unwind this transaction? As Nilang rightly said, how do you put the paste back into the tube? It's going to be impossible to do that. And that, I think, is a very compelling reason for the reconsideration and having other. Secondly, I think the commercial aspect today should be, if nobody is truly aggrieved, if the creditors COC are happy with it, they should just call for COC. Under IBC, there is an ability to liquidation under going concern. Simply offer that to JSW on a first basis immediately to say that because they've been running this plant, we have taken a call to give it to them on a liquidation base without calling bids, or call limited bids if you want to tick the box and manage the other stakeholders to say they should not be bidding. Ideal. The only risk there is somebody else may come and bid and take it up. But I'm saying that's one option. The other option is, if you have to rerun the process, I think JSW should file a massive claim to say that they have they took over a plant which was 2.7 million metric tons at 40% capacity. They took it up to 5 million now, I think 4.7 something of capacity at 100% utilization. That's the reason why it makes money. They should claim complete compensation for this, and that compensation will be a poison pill for anybody else to get. So I think there is a commercial resolution whilst the legal is pursued, and that should be followed.
Right. One final question to both of you gentlemen. Nilang, how much of sticking to procedure do you think is sufficient to not invite the wrath of the top court, like has happened in this case? Who draws the line? I'm going to come back to toss the proportionality aspect back to you when it comes to procedure.
I'll be very honest. I still think that whether procedure was entirely followed or not is a factual question, and we'll wait to see whether that was done or not. But it seems to me to be over here 100% a test. And if you don't, then the consequences could be, the ultimate. And again, back to what Abizer said, right?
So I think this is again judiciary stepping into execution. Execution should have a leeway to implement in spirit, and just making sure that regulation is followed does not ensure spirit ever. So I think the spirit needs to be looked at by the courts in terms of making sure that a resolution plan is effective.
Right. There you have it, folks. We've tried to present to you a 360-degree view of various aspects of the impact of this precedent-setting order that has caused quite a flutter in corporate India. On that note, I must thank both my guests, Nilang Desai as well as Abizer Diwanji, for taking out time and sharing their perspective.
Thank you.
Thank you.
With that, it's a wrap on this edition of Deal Central. Stay tuned to Moneycontrol for more news, views, and updates. This is Ashwin Mohan signing off.